Welcome to our Immigration Law Deep Dive. In this episode, our legal analysts explain one of the most significant proposed changes to the UK's immigration system in clear, straightforward language. Using official government publications and primary legal sources, they separate confirmed legal changes from proposed reforms, helping you understand what the changes could mean for individuals, families, employers, and sponsors. Whether you are directly affected or simply want to understand the latest developments, this discussion is designed to make complex immigration law accessible to everyone.
Imagine waking up, checking your email, and seeing a message from the government that says, your path to permanent residency just doubled.
Just completely out of nowhere.
Right, like the finish line you've been working toward for years went from 5 years to 10, and it applies to you right now, even though you already live here. You know, you pay taxes, you play by the rules.
It's a terrifying thought.
Yeah.
And for hundreds of thousands of people in the UK, that email might actually be coming.
Exactly. I mean, trying to follow UK immigration news in 2026 is just incredibly overwhelming. You log online and you just get this deafening blast of static.
Oh, absolutely. It's just noise.
Yeah, law firm bulletins screaming about panic, angry opinion pieces, political grandstanding, and just rumors disguised as facts. And if you are one of the millions of people whose actual life depends on these rules, that noise isn't just annoying, it's genuinely terrifying.
The sheer volume of information being thrown at people daily, I mean, it makes it nearly impossible to figure out what is a new law, what's a proposed idea, and what is just a headline meant to get clicks. The anxiety that creates is very real, and honestly, very understandable.
Which brings us to our specific mission for this deep dive. We are stripping away all that media spin and the political noise, and we are looking strictly at the primary sources.
The actual documents.
Right. We've got the official Home Office publications, the gov.uk policy updates, the Home Secretary's actual speech transcripts, and the raw government data releases.
And right at the top, I want to make a very clear promise to you listening. As an immigration expert, my role today is basically to be your translator.
Yep.
We are taking dense, highly technical governmental policy and turning it into clear layman's terms. And more importantly, we're doing this with absolute neutrality.
Zero spin.
Exactly. We take no political sides here, neither left-wing nor right-wing. Our only goal is to impartially decode the official facts and data. So, you know exactly where things stand.
Just facts. But before we jump in, a quick note for you listening. If you want to read the full breakdown of these documents, visit our website. The link to the full article is down in the comments.
Highly recommend checking that out.
Yeah, it's super helpful. And please make sure to like, comment, subscribe, and follow us right now. You'll definitely want to be notified about our next live webinar. It's a rare opportunity to ask live questions about your own immigration journey or, for your loved ones. You really don't want to miss that.
It's going to be a great session. So where should we start?
Let's start with the reality on the ground. Instead of starting with the rumors, what has actually been officially rewritten in the legal code this year?
Right. So the best place to start is with the immigration rules themselves. We've had two major updates this year that are entirely locked in.
Okay.
The first happened in March, and it heavily impacted the asylum system. There is a critical detail here for anyone navigating that specific system, and it revolves around the path to settlement.
Which is always a huge point of stress.
Definitely. So the Home Office set a hard line in the sand, March 1st, 2026. If an adult or a child submitted their asylum claim or their further submissions before that specific date, and they were granted 5 years leave, they are grandfathered into the older 5-year path to settlement.
Wait, why draw a hard line like that? Like, is it just about avoiding administrative chaos, or is there a legal reason they protect people who applied before March 1st?
Well, it is a mix of both, actually. Retroactively applying new, stricter timelines to people who have already been navigating a backlog system for years.
That sounds like a lawsuit waiting to happen.
Exactly. It invites massive legal challenges. It violates the principle of legitimate expectation. By drawing a line, the Home Office stabilizes their own processing queues and avoids tying up the courts.
It gives people certainty.
Right. It provides certainty for those who are already stuck in the system.
Okay, so that was March. But if we fast forward to the summer, we saw another massive sweep of technical fixes across almost every visa category. I'm talking skilled worker, student, global talent, all of it.
Yeah, July was a busy month for updates.
It really was. And hidden in all that jargon, I noticed a specific change to family visas. It seemed to fix this really strange bureaucratic mismatch regarding how long certain visas lasted, like a bug fix.
It did, yeah. Under the family visa rules, there was a deeply frustrating flaw. Previously, if someone was granted permission to stay as a refugee, they were given 30 months.
Okay, 30 months.
But if their partner or child applied to join them, the system rigidly granted the family member a 33-month visa.
Wait, meaning their visas expire at completely different times? I can't even imagine trying to manage a household where the primary earner's legal status expires, like 3 months before their child's.
It was a nightmare.
I mean, that means paying massive renewal fees at different times, right? And
Yeah.
constantly tracking overlapping deadlines, like a software terms and conditions update that actually alters people's lives.
Precisely. You'd have a family risking someone accidentally overstaying just because of a purely administrative staggered timeline. But the July update fixes this.
Oh, thank goodness.
Yeah, now the partner or child's visa end date can be synced exactly to the sponsor's end date. It's a small administrative tweak, sure, but for a family navigating a new country, that alignment removes a huge layer of bureaucratic stress.
Yeah, I bet. Not all the summer changes were about making things easier, though. There was a pretty significant tightening of the deportation rules, specifically around suspended sentences.
Yes, the deportation thresholds.
Right. I read the explanatory notes from the Home Office on this, and they basically claim this wasn't a brand new policy, but essentially a typo fix regarding dates. How is changing the threshold for deportation just a typo fix?
Well, it comes down to the difference between when an offense occurs, when a conviction happens, and when a sentence is handed down.
Okay, break that down for me.
Previously, the threshold for automatically considering someone for deportation was an actual custodial prison sentence of 12 months or more. The new rules catch people given a suspended sentence of 12 months or more.
Wait, so no actual jail time, just suspended?
Right. The Home Office's official notes state the original wording was poorly drafted. It triggered the rule based on when a suspended sentence was given, so at the sentencing hearing. But legally, they intended the trigger to be the date of the underlying conviction.
So a person might be convicted in February, but not actually sentenced until April, and the Home Office wanted the rule tied to February.
Exactly. This rewrite corrects that phrasing for convictions made on or after March 22nd, 2026. But, regardless of whether they call it a phrasing correction, the real-world impact is undeniable.
Yeah, a technicality with massive consequences.
A 12-month suspended sentence, where you do not actually go to prison unless you break further conditions, now firmly puts you in the automatic deportation consideration net.
Wow. Okay, so those are the rules firmly on the books. March and July are done deals. But if the Home Office is extending and tightening these timelines, it means people are stuck in the system longer, which brings us to the horizon.
The upcoming proposals.
Exactly. There is a massive proposal looming that, if passed, would completely alter the future for hundreds of thousands of people currently working in the UK. I'm talking about the earned settlement proposal.
Right, and we need to be extremely precise here. This is a proposal. It was introduced in a formal consultation document called A Fairer Pathway to Settlement, which closed back on February 12th, 2026.
So it's not law yet.
It is not law yet. But the government's stated intention is profound. They want to change indefinite leave to remain, or settlement, from something you get mostly just by living here for a certain amount of time to something you must actively earn.
And the headline here is doubling the default qualifying period from 5 years to 10 years.
Which is a huge jump.
Massive. But it isn't just about waiting longer. The consultation outlines a massive list of requirements people would have to meet just to qualify.
That is the core proposal. 10 years to reach settlement. The consultation does state that people could still qualify at 5 years or earlier, but only if they meet extremely strict criteria.
Like what kind of criteria?
Well, things like an exceptionally high standard of English, a completely clean criminal record, a measurable economic contribution, and absolute zero debt in the UK.
Okay, pause. When they say zero debt, what exactly does that mean? Are we talking about like a car loan, a mortgage, or something else entirely? Because basically everyone has some form of debt.
It typically refers to debt owed to the state.
Oh, I see.
This means unpaid NHS bills, litigation debt owed to the Home Office from previous visa appeals, or unpaid council tax. It does not usually mean a personal mortgage or a standard credit card.
Okay, that makes more sense.
But the strictness is the point. The Home Secretary was explicit in her speeches. that this intends to catch people currently in the UK who haven't yet reached settlement.
Wow.
She specifically referenced the hundreds of thousands of lower-skilled workers and their dependents who arrived between 2022 and 2024.
So people who arrived under one set of rules, completely expecting a 5-year journey, could find the rules changed while they are already midway through the process.
That is the fear, yes.
It's like running a marathon, reaching mile 20, and the officials suddenly announce the finish line is 10 miles further away. But there's a detail in this consultation that feels like a massive paradox.
Which part?
The part where the consultation proposes that people on lower wage routes, and they explicitly name health and care visas, would face a 15-year wait for settlement.
Yes, that part is very controversial.
Right. Yet, in the exact same breath, public servants, specifically NHS doctors and nurses, might get an earlier fast pass to settlement. How does a care worker on a visa face a 15-year penalty box while a public servant nurse gets a fast pass? What is the actual mechanism driving that logic?
If we look at the government's broader economic logic outlined in the consultation, and again, remaining totally neutral on whether we agree with it, their argument is purely fiscal.
Fiscal as in tax revenue.
Mostly, yes. The government views lower wage routes, like basic social care workers, as representing a greater long-term cost to public finances over their lifetime.
Because they might need more state support or health care as they age, relative to the income tax they pay in.
Exactly. The Treasury calculates the lifetime tax contribution versus the lifetime cost of public services consumed. Therefore, the proposal suggests they must contribute for 15 years before the state takes on permanent responsibility for them via settlement.
And the doctor.
Higher-earning public servants, like specialized doctors, are viewed as immediate, high-value net contributors to the state infrastructure. So the proposal floats using early settlement as a retention incentive to keep doctors in the country, while using the 15-year delay as a fiscal buffer against lower-wage workers.
That is a stark, purely economic way to view human labor. And again, for you listening, as of right now, this is just a consultation. It closed in February. The government hasn't published its final response yet, so it's a storm brewing, but it hasn't made landfall.
Exactly. We have to wait and see.
But if these timelines are getting stricter and longer, that puts a massive prolonged burden on the people who have to sponsor and monitor these visas, the employers. Which brings us to the October 1st deadline.
This is critical. For anyone running a business, an HR department, or a recruitment agency, you need to be paying attention. The Home Office has issued a new draft code of practice on preventing illegal working.
Specifically updating the right to work scheme, right?
Yes. And the commencement date for this is October 1st, 2026.
So what does that actually look like in practice for an HR manager? Like, what are they physically doing differently on October 1st?
Well, they are going to be heavily relying on the Home Office's online checking service. Physical document checks are becoming increasingly obsolete for many visa holders.
Good to know.
The HR manager must obtain a share code from the prospective employee, log into the government portal, and verify the digital status. The new code dictates the exact steps, how that digital check must be recorded, and how follow-up checks must be scheduled before a current visa expires.
And what if they mess up?
If a share code expires, or if an employer misses a follow-up check date by even a single day, liability shifts instantly. If you employ someone who turns out not to have the right to work, and you didn't follow this new digital code to the letter, you face severe civil penalties.
Ouch.
And if you knowingly employ them, it's a criminal offense.
But there's a second companion code of practice launching at the exact same time regarding discrimination. This seems to create a massive paradox for employers. It's like a corporate pincer movement.
Oh, it really is.
On one hand, the Home Office is threatening criminal penalties if you don't aggressively root out illegal working. On the other hand, this companion code threatens legal action under the Equality Act 2010 if you discriminate while doing it. So as an employer, how are HR departments supposed to balance that?
It is the ultimate compliance dilemma. How do you rigorously investigate someone's immigration status without unlawfully profiling them?
It sounds a bit like the TSA at an airport. Like, if you randomly pull people aside for extra screening just because of how they look or their accent, you're profiling. That's illegal.
Exactly.
The only way the security system is legally defensible is if every single person takes off their shoes and goes through the exact same scanner every single time without exception.
That is the perfect analogy. The Anti-Discrimination Code essentially tells employers that the only way to survive is through absolute, rigid procedural consistency.
So no gut feelings.
None. You cannot look at a candidate's name on a resume, hear their accent in an interview, and decide, I'd better do a deeper right-to-work check on this person just to be safe.
Because applying extra scrutiny based on a hunch is inherently discriminatory.
Correct. That directly violates the Equality Act. The guidance requires you to apply the exact same rigorous right-to-work checks to every single candidate, universally, before employment begins.
Wow, every single one.
Whether they were born in London or Lahore, the procedural hurdle must be identical. If you deviate from your standard process based on assumptions, you lose the protection of the code.
So the takeaway for businesses is update your standardized digital process to match the October 1st rules, and then enforce it blindly and universally across your entire workforce.
That's exactly it.
Okay, so we've looked at the individual rules changing, the 10-year settlement proposal, and the strict new employer mandates. Let's zoom out for a second. Are these incredibly strict policies actually showing up in the numbers? When we look at the actual Home Office quarterly data for March 2026, what is the reality on the ground?
The macro picture reveals some dramatic shifts. Let's start with the sheer volume of movement. In the year ending March 2026, there were 136.8 million arrivals to the UK.
Wait, what? That number sounds staggeringly huge. That's more than double the population of the UK. How is that even possible?
Right. It requires a very important caveat. 57% of those arrivals were British nationals.
Oh, okay. That makes a lot more sense.
Yeah, this statistic counts total border crossings, not unique immigrants. It counts every time a British citizen returns from a weekend holiday in Spain or a business trip to New York. So we have to separate overall border traffic from actual long-term immigration data.
Right. So what about the specific areas where the government has been focusing its hardest policies, like asylum and border enforcement? Are the policies actually working?
That's where we see the most significant trends. The asylum backlog has plummeted. At the end of March 2026, there were roughly 49,000 people awaiting an initial decision.
Which is still a lot, but...
But that is a 55% drop from the previous year and a massive 72% drop from the peak of 175,000 in June 2023.
That is a huge drop. What is driving that? Is that a result of fewer people applying, or has the Home Office just hired more caseworkers and streamlined their processing?
It is largely driven by processing efficiencies and targeted policy changes to clear older cases rather than a massive drop in global displacement.
Okay, so just better paperwork management.
Exactly. The government made a concerted effort to process legacy claims. On the enforcement side, enforced and voluntary returns are up 7% to 39,000.
I also saw a statistic about illegal entry at ports. People detected trying to sneak in via ferries or the Channel Tunnel. That number dropped 80% since its peak in 2019. It was down to just 227 people for the entire year.
Yes, a very steep decline.
Why such a massive drop? Is that just better fencing and technology at the ports?
Better technology and closer cooperation with European border forces at juxtaposed controls certainly play a huge role. But in migration studies, there was a concept known as displacement.
Displacement.
Yes. When you heavily fortify one route like sneaking onto a lorry at a traditional port, the migration flow doesn't necessarily stop. It displaces to a more dangerous, less regulated route.
Like small boats.
Precisely. The hardening of official ports is directly correlated with the rise in alternative methods over the last few years.
That makes total sense. Now, the statistic that really caught my eye in this data release was about students, specifically the graduate visa route.
Yes. The data shows that graduate route extension grants fell by 36%, down to roughly 167,000.
When you first hear that, the immediate assumption is that international students simply stopped coming to the UK because the environment feels too hostile. But the data reveals something much more surgical, doesn't it?
It really does. The 36% drop wasn't driven by a massive exodus of the graduates themselves. It was driven entirely by policy.
What policy?
The grants to dependents of graduate visa holders were slashed by 75%.
It's like looking at a massive plumbing system. The government didn't shut off the main water line, the actual students coming to study. They just turned off one very specific valve, which was the dependent visas.
That's a great way to look at it.
And by turning off that one valve, you watch the pressure in the entire demographic pipeline drop by a third overnight.
It perfectly illustrates why reading the actual rules, rather than just the headlines, is so crucial. A headline might say, graduate visas plummet, implying the UK has lost its appeal to global talent, perhaps harming the university sector permanently.
Right.
But the data reveals it's a direct consequence of a specific restriction on family members accompanying those graduates. The talent is largely still there, the family units are not. A single targeted rule change can instantly alter a macro statistic.
So what does this all mean for you, the listener, trying to navigate this landscape in 2026? Let's sort of synthesize everything we've covered today.
The core takeaways are structured around three distinct timelines. First, the past rules that are now active reality. The March and July rulebook rewrites are locked in.
The grandfathering of asylum claims.
Right, the grandfathering of claims before March 1st, the syncing of family visa dates to relieve bureaucratic stress, and the tighter deportation triggers for suspended sentences. Those are happening right now.
Got it. And the second timeline?
Second is the immediate future. October 1st is the hard deadline for employers. If you run a business, your digital right-to-work compliance must be updated to the new codes, applied universally without discrimination by that date.
Universal checks, no profiling.
Exactly. And third, the horizon. The 10-year earned settlement proposal is the massive storm still brewing. It is not law yet, but it is the clearest signal of where the Home Office intends to go regarding long-term residency and the economic value of different visa routes.
So what's your ultimate advice?
My key advice: constantly monitor the official Home Office guidance, because as we've seen today, the ground under your feet is highly volatile.
It is extremely volatile, but breaking it down like this really helps clear the static. For you listening, don't forget to click the link in the comments to read the full article on our website, where we've linked all these original government documents and data releases so you can read them yourself.
Definitely go read those source documents.
And please, like, comment, subscribe, and follow so you don't miss our upcoming live webinar. It is a fantastic opportunity to get your specific immigration questions answered by experts like we have here today.
I'm looking forward to it.
Before we go, I want to leave you with a final thought to mull over. We spent a lot of time unpacking that earned settlement proposal, the idea that to earn the right to stay permanently, an immigrant might soon need to prove 10 to 15 years of perfect legal compliance, advanced English, flawless economic contribution, and absolute zero debt to the state.
A very high bar.
It makes you wonder, if you applied those exact same strict criteria to the people already living here, how many native-born citizens would actually pass their own country's test?
That is a very good question.
Something to think about the next time you hear that radio static. We'll catch you on the next deep dive.